Forensics. Our last video was all about what is a crime scene and laws of forensic science which are mandatory to investigate a crime scene. Each crime scene is unique because the chain of events that create it is unique, but there is uniformity in how to study and process a crime scene. Therefore, in this video, we will talk about fundamentals of crime scene processing as the crime scene is constantly changing and decaying after its creation. We will also emphasize on methods to document a crime scene to preserve the information for later studies. Locard's principle of mutual exchange becomes very important at scene of crime. The job of crime scene investigation team is to look around for physical evidence which are generated due to coming in contact with suspect or victim. Now, we must know who's involved in a crime scene investigation. Professionals at the scene of a crime may include police officers, crime scene investigators, and scientific specialists. Question may arise here. What role does forensic expert play at a crime scene? The answer to that is, on the request of investigating officer, the forensic experts can assist in collection of crucial evidence within which the crime has occurred by restricting all unauthorized persons from entering, keeping a security log of all those who visit the crime scene, collect pertinent information, and request additional manpower and field experts related to crime scene if required. If there are witnesses, they must not be allowed to talk to each other. This separation is done to avoid witnesses working together to create a story. After the crime scene has been secured, it should be recorded properly. Photography and videography of overall area and close-up photos with and without a measuring ruler should be taken. A view of the crime scene should be taken from several different angles and distances. Several close-up photos of any evidence and bodies should be taken. Make an accurate rough sketch of crime scene, noting the position of body and any other evidence. All objects should be measured from two immovable landmarks. On the sketch, north should be labeled and a scale of distance should be provided. Any other object in the vicinity of crime scene should be included in the sketch. Later, a more accurate final copy of the crime scene should be made for possible presentation in the court. Notes taken at crime scene also play an important part in recording the crime scene. Search for physical evidence must be thorough and systematic so that no evidence is missed. The searching pattern normally depends upon the type of crime scene and number of investigators available. The following search patterns ensure that no area is left unsearched. Number 1. Strip or line method. The whole area has been sealed into rectangle and then search is proceeded parallel to one side of rectangle. Number 2. Spiral method. The searcher starts the searching from the point just outside the area of crime scene and move along the path of spiral till they reach the crime spot. Quadrant or zone method. The entire area to be searched is sealed into a big square. The big square is then subdivided into 4 small squares assigned to different searchers. Wheel or ray method. The entire area is marked as circle. The searcher may start their search from the center and proceed along the radii. The collection of evidence depends upon the type of evidence on a crime scene. Temporary, fragile, or easily lost evidences should be collected first. Protective clothing should be worn at the crime scene while collecting evidence. Always follow standard procedures and techniques for evidence collection and storage. For example, blood sample should not be packaged in wet condition. It should be air dried after collection. All evidence needs to be properly packaged, sealed, and labeled. An evidence log and a chain of custody document must be attached to the evidence container. The evidence log should contain all pertinent information, including case number, description of evidence, name of victim, name of suspect, date and time of recovery, signature of person recovering the evidence, signature of any witness present during collection. Chain of custody refers to the process of maintaining and documenting the handling of evidence. It involves keeping a detailed log showing who collected, handled, transferred, or analyzed evidence during an investigation.
Okay, so those were the steps, the basic steps in a crime scene investigation. So welcome today to our first class, or one of the main classes that we're going to be talking about crime scene investigation and murder. We're going to see how we're going to understand the whole process of the crime scene investigation. So we already checked those steps before. We checked before what is crime investigation. We check how the crime investigation is going to be performed. But now we have to understand how to process the crime scene in the court. So when I'm talking about the court, it's going to be all the allegations, all the commitment from the district attorney, all the commitment from the police officers to demonstrate, to prove that a homicide, crime was actually perpetrated. So please take a time to wear any earphones, try to make it as clear as possible, because we're going to have a simulator right now, okay? So with this simulator, we're going to be understanding the boundaries of the law. So whenever I'm trying to say is that law is going to be performed by police officers, right? But in the matters of law, we'll have to understand how secure is to share the information. If that information can be shared with other parties, or if it cannot be shared with anybody at all. So we're going to use our simulators to see what is the evidence trial. So right now, I need you to use your glasses, to use everything you have right now, so we can go and schedule it as it will be a real crime scene investigation. So remember that crime always needs a motive. There's always a way to get away with murder. But how do we get away with a murder? Well, that's not going to be easy. We're going to see what are the rules of law and how law is going to be our boundary that we will be able to understand. Interpret the law, interpret the circumstances, interpret the evidence, interpret the witness, so we can convince the jury. Remember, the people that we need to address, the people that we need to convince is going to be the jury, okay? It's not going to be the judge. We don't care about the judge. The judge at the end, yes, it's going to be very important that you will be able to address him, will be able to get all the ideas necessary to the judge, but the one that is going to judge the whole thing is going to be the jury. So next class, we're going to see how is a jury assembly in real life and how this jury assembly is going to be taken into account into a conviction. Okay, so let's see how we can use this simulator in a different way. So what are we going to be using? Well, the first thing is, what are the steps of the trial? The first step of the trial is going to be an accusatory pleading. Repeat after me, accusatory. Accusatory. Again, accusatory.
Accusatory.
Very good. And then we say, good, pleading. Again, pronunciation, pleading.
Pleading.
Very good. Accusatory pleadings. Again, accusatory pleadings.
Accusatory pleadings.
Very good. So what is the accusatory pleadings? Are going to be the written notice, okay? How I'm going to make the accusation. So that accusation, it has to have a legal background. That is the whole legal background. We're going to see how we're going to do it. Number two is going to be the citation. Again, pronunciation, citation.
Citation.
Very good. So what is the citation? Well, the defendant doesn't know that he's being accused of a crime unless we have it figured out and the evidence. Unless we know for certain it's him and it was a real event. So if it was a real event, we're going to take into consideration and then we're going to take him to the proceedings immediately. But if we're investigating, then we're going to cite. We're going to have a citation of the people involved. Okay, so let's see how we're going to figure out the next ones. So what are these ones? Well, we're going to see from there. Number one, understanding and filing the accusatory pleadings. That's the first thing we have to do, to understand and filing the accusatory pleadings. Again, repeat after me, accusatory pleadings.
Accusatory pleadings.
Ulises?
Accusatory pleadings.
Very good. Good pronunciation. So let's understand. Number one, let's understand these accusatory pleadings. Well, the first thing is to understand that accusatory pleading are formal written statements presented in a court of law that charge an individual with a specific offense or offenses. Okay? So again, accusatory pleadings are formal written statements presented in a court of law that charge an individual with a specific offense or offenses. So written testimony, written accusation, everything is going to be written. Okay, so please start with the pronunciation, Ulises. Accusatory pleadings.
Accusatory pleadings are formal written statements presented in a court of law that charge an individual with a specific offense or offenses.
Excellent, very good, Janet. Accusatory pleadings.
Accusatory pleadings are formal written statements present in a court of law that charge an individual with charge an individual with a specific offense or offenses.
Offense.
Offense.
Very
offense
good.
Or offense.
That's right. So the accusatory pleadings are going to have three important things that we're going to be analyzing with the law. Okay. So the first accusatory pleading is going to be the document, the outline of the charges against the defendant. So in this case, we have this person that is being accused of the crime. Remember, the person accused of the crime, we call him a defendant. So what are we going to prove? We're going to prove the basis of the prosecution case. So the prosecution case is going to be the theory of the case. Why do you think the case happened? Why are you accusing the person? So this accusation of the person needs to have a legal violation. Repeat after me. Legal violation.
Legal
Legal
violation.
Very good. This legal violation, it has statutes and laws. Estatutos y leyes. Statutes are going to be secondary laws. Laws are going to be the proceedings. Statutes and laws. Laws and statutes are not the same. But basically, we're going to say most of the statutes are generated by the executive power. So the legal violation in this case is murder. So this person killed another person. That is murder. The statute and law is based on the Penal Code section 187. The elements of the crime is going to do two things. We're going to need to prove two things. Actus rea and mens rea. Okay? Again, pronunciation. Murder.
Murder.
Assassination. Okay? To assassinate a person, it's murder. Okay? Penal Code section 187. We don't say 187. We don't say that. We say Penal Code section 187 or 187. We don't never say 100, 200. We don't say that. We only go Penal Code section 187. So we provide the elements of the crime stating the actus rea and the mens rea. So in the actus rea, we're going to check what is the intention of the defendant. If the defendant had an intention to perform the act or if it was unwilling. So to that extension, we're going to see also how the defendant thought. What were the thoughts that got him into the prosecution? So for that, we say mens rea. But let's analyze each one of them very clearly. What are the basis of the charges? Okay, so if we want to defend a person, if we want to say, hey, let me know why are you accusing of this person, the best way to go and say this question is, what are the basis of the charges? Repeat after me. What are the basis
the basis
of the charges?
Of the charges.
Okay, so let's suppose that you are having a pina colada. So as you're having your pina colada, a person comes and puts you into arrest. So if they put you into arrest, you can defend the person and say, hey, what are the basis of the charges? Or you can say, under what charge? Okay, so if we're lawyers, we have to speak like lawyers. But if we are not lawyers, we're not supposed to speak like lawyers. We can speak like we want. So you can say, charges, what are the charges? What are the charges? What are the basis of the charges? You can say both. Very easy. What are the charges? What are the basis of the charges? What are the basis of the accusation? So it allows the defendant to understand. First, the defendant has to understand why he's being accused, why he is being now accused of a crime. So we need to understand the accusation fully. It means to all the extent. Why do we need to understand this? To prepare a defense. Okay, so as we're going to prepare a defense, we can say two things. Look, it was you, so we can say guilty or not guilty. Very, very simple. We don't say innocent. Never. We never play for innocent. We say guilty or not guilty. How do you plead? So when the judge asks you, how do you plead? You say guilty or not guilty. You don't say innocent. You can say I am innocent, but that doesn't make any sense. What it really makes sense is if you're guilty or not guilty. Okay, so we can challenge the prosecution case. Pronunciation, challenge.
Challenge.
Challenge. Again, very good. Challenge. Very good. So we challenge the prosecution case. Again, pronunciation, challenge the prosecution case.
Challenge the prosecution case.
Prosecution. Prosecution's case.
Prosecution's case.
Again,
prosecution, que- prosecution,
prosecutions.
prosecution's case.
Very good. Ulises?
Challenge the prosecution's case.
Okay, let me ask you this, Ulises. If somebody is guilty of a crime, do you think it's a good idea to say, I'm guilty?
No, it is not a good idea.
Might not be a good idea, right? Why? Because probably there might be a way to prove that you're not guilty, or there might be circumstances. For example, a wife, okay, a person that has been harassed by the husband, and one of the days she just pushes away the husband and the husband dies. She's guilty, yes, she's guilty, but there might be a way to exempt the guilt. Okay, maybe like self-defense. Maybe that's one of the things. So we have to analyze two things: actus rea and mens rea. Again, pronunciation: actus rea.
Actus rea.
Rea.
Very good. Mens rea.
Mens rea.
Very good. So actus rea is the action that you performed. Okay, in this case, the homicide itself. You know, there is a person, there is the blood, there is the knife, everything. That's the actus rea. That's what happened. The mens rea is the intention of the person. What's the guilt mind? What was in his mind in order to perform the action? So the mens rea, we're gonna see what was he thinking about. So there are only two ways to demonstrate that the person proved beyond any reasonable doubt that there was a causation or not causation. That's the most important thing about investigating a homicide. What is the causation of the crime? As I said before, if there is a wife, okay, there is a wife that is being molested all the time by the husband, is being instigated, she's been manipulated, and then, you know, she's been smacked every day she smacks her and smacks him, you know, that's gonna provoke an action, right? So we need to see what is the difference, okay, between what happened and to what it was the intention of the person. Probably the person was just defending themselves and they just pushed away. So if they just pushed away, what was the intention? So that intention, we're gonna say mens rea. Again, pronunciation, mens rea.
Mens rea.
Mens rea.
Actus rea.
Actus rea.
The action itself. Okay, so actus rea, mens rea. Now, the connection, the consequence of this, the actus rea and the mens rea, is the causation. Okay, so we have two types of causation: direct cause, the act led directly to the legal violation or the harm, or proximate cause, substantial factor in causing the harm. Okay, so it's gonna be a little difficult. It's not gonna be easy to understand both. We're gonna see it today and in the next class. But on causation, everything is what we prove, or we knew proof, or we cannot prove on court. Okay, so on court, we're gonna say that there is causation, and of causation for the evidence. So if there is no causation, it means that you don't have enough evidence to prove the actus rea, to prove that that person was indeed guilty. Okay, so let's go and continue. Accusatory pleadings will always be based in legal violation, statutes and laws, elements of the crime. What are the elements of the crime? Actus rea and mens rea. Now, this acts is before it allows the defendant to understand the accusations fully, to prepare the defense and challenge the prosecution case. Actus rea, mens rea. The consequences of this are the causation. Okay, so this causation is going to establish if the person is guilty or not guilty, if there is a way to prosecute the case, or if you can challenge the prosecution case. Okay, so from there, let's start with the next. An example. We have a car. Okay, so the car goes between 10 miles per hour, between 20 miles per hour, and then increases to 30, 50, 60, and it goes further and further, and it doesn't obey any traffic sign. So probably there is a traffic sign, and in the traffic sign, he says, nah, no, no, there is nobody around. So he continues to drive, he continues to drive, he continues to drive, and then it becomes a chain of events. So the intention of the person is not to kill a person. The intention of the person is just to drive recklessly. There is a traffic light, but he doesn't stop. He continues and he continues and he continues. So this creates a lot of events. So first, one event, then one event. So there's one traffic light, there is another light. So there is a cause in fact. The cause in fact is all the chain of events that were performed. But let's see what's the other event that comes up. Let's suppose that there is a runner. There is a person that also at this time at 10 p.m. she likes to jog around. So she's jogging and there is a car. So if there is somebody jogging at that time, the person has two choices. Either he stops, or if he doesn't stop, then he's going to collide. So the direct cause is going to be changing from the leading the defendant's action to an inaction, to perform harm or not to perform harm, to create a damage or to experience the damage. So that is the experience that we need to address in court. How were the situations going to be based on causation? If the defendant was able to stop, or if the chain of events continue to happen in motion without a way to stop them. So that direct cause is going to be satisfied with a mere element. This mere element is that there is an injury. So when it happens, the injury, the pedestrian in this case, the pedestrian injuries wouldn't have happened if the car had stopped at the red light. So that's how we understand the differences between causation and approximation. So let's see again. Causation, it's all the events that are going to happen. The action or inaction to harm or to damage a person. But that action or inaction will have to come from a consequence. That consequence is called the chain of events. So the chain of events is how we continue on these events without stopping. Could we prevent the first event? Yes, probably if this guy actually stopped from the beginning, probably the jogger will then be injured. So all of that is called direct causation. Again, repeat after me, direct causation.
Direct
causation.
Very good. So if there is a direct consequence, we say that there is a direct causation. So we say, oh, there is a direct consequence. No, we say it's a direct causation. So the causation is going to be the action or inaction to perform damage. How it could be prevented. What were the consequences of those chain of events? If those chain of events were liable or non-liable. So we have two choices. If we make them liable, it can go to a criminal court. And we're going to see if the damages, these damages, will be superior or not superior. Remember, if they're under 5,000, then it goes into small claims acquisition. But if they go beyond $5,000, then it has to be in a superior court. If it goes into a civil court. But if it doesn't go into a civil court, then it's going to be in a criminal arena. And in that criminal arena, he's going to be accused of all the acts and events that happen to him. Okay, so let's see and practice the vocabulary we just learned today. So we're going to see an accusatory pleading. So an accusatory pleading is everything that I just explained. Is how were the consequences, how were the causations performed. All of that is going to be in a formal written statement. So in the formal written statement, we're going to see how we can present it to court. So if we're going to present it in court, we're going to see what are the charges that's going to be outstanding or not outstanding, if they can be proven in court or if they cannot prove in court. If they can be proved in court, well, how can they be proved? Could they be, is there a necessity, a way to perform a duty with a specialist? So if this specialist is around, what will be the specialist thinking about? So how do we do this? Well, that is how we understand an accusation. So when understanding an accusation, we have to go to the pleadings. So these pleadings are going to be written. Let's see an example of how is an accusation in real life. So this is an accusation for a cybercrime. And it goes like this. All the accusations, as I said before, are direct. Okay? So it's always going to start with the district court where it comes from, the location, the jurisdiction, and the docket. What is the docket? All the elements of the accusation. So there's always an accusation, which we're going to call indictment. Okay, so the indictment is going to have all the information regarding to the accusation. So that information regarding the accusation is going to be asked in a criminal docket. Then we're going to be assigned a case number. In this case, this is the case number assigned to this case. And always we're going to see the state versus the last name of the person. So it's the United States versus white. So in this case, it means that this is a federal case. So if this is a federal case, it means that it's a federal prosecution. So always against a person. In this case, we have the person, which is this person. Other court case numbers, it means if there is a previous case or a previous accusation, you can also put it here. So you go and say, okay, who's the defendant? Ayla White, the date of birth, 1965, Russian terminated. It's on July 12, 2021, the last time that they met on court. Who is the lead attorney? Attorney to be noticed. It means that there is still citation to perform. The pending counts, none, the deposition, if there is any disposition, terminated counts, highest offense level, complaints. What is the complaint? What is the crime? Well, here is the crime. Conspiracy to commit computer fraud and aggravated identity theft. Conspiracy to commit wire bank fraud, wire fraud bank fraud, aggravated identity theft, conspiracy to commit money laundering. So when we have this word that says conspiracy, it's complete. Why do we say complete? Because it has all the change of events, all the causation. So if there is a direct causation, then we only go and say aggravated identity theft. But if it's a proximity causation, then we're only gonna say conspiracy to commit money laundering, because it's one event, one chain of events that leads to another. Okay, so then it goes here. Remember that when you read an accusation, always have to be careful with the information that you're reading. Most of the information, it's public domain. So you can study anywhere this information, but remember that it's always private on the matter of the settings. So the settings that we're going to be accumulated, the settings that we're going to be using, it's going to be what's going to make it a special accusation. In this case, we have, it's an electronic crime. So all the electronic crimes are going to be federal, but are also going to be state crimes. So this is state crimes. We're going to see when is going to be the state crime. How is it going to be performed? In this case, we have 70 pages just of an accusation. So let's see how the accusation starts. So it comes like this, and it says the docket. In the docket is going to have all the evidence, everything, all the motions that have been performed in order to have the case open or closed. In this case, it's magistrate's removal of indictment from USDC from the North District of Ohio, case number of the District 120. Attorney updating case to Ayla White, attorney noticing invocation of the right of silence and counsel by Ayla White. So in this case, we have that Ayla White remained silent before the prosecution office. The minute order for proceedings held before magistrate judge Alicia Otazo Reyes. So we can look for the judge, the experience of the judge, always check that. The initial appearance of the Ayla Watt held on the 2nd of August to 2021. The date of location of the costing, arrest or surrender, if there was an arrest or if there was a surrender. It is ordered and adjusted pursuant to the Due Process Protection Act. The court confirms the obligation of the United States to produce all exculpatory and impeachment evidence to the defendant pursuant to Brady versus Maryland. So we have the basis of the law and the basis of the charges. So then we continue, and here's when it was filed. Okay, so this is the seal of the Angela E. Noble Clerk, U.S. District Attorney. So Angela Noble is the district attorney, and this is the date that it was issued. And we have also the timestamp, and the timestamp, we have the time, which is 1:20, and the motion office that attended it. So then we have the arrest warrant. So in this case, it was under an arrest. Who they took under arrest? They took under arrest Ayla White, AKA, if there's any other nickname, so it's AKA Max. There was an indictment, that is the accusation. Accusation is an indictment. So then we go with the signatures, who is issuing offers, what's the office in Cleveland, when it's going to be performed, and it goes from there. What is the indictment number, the general allegations, who's the defendant? In this case, if there are more defendants, they can be protected. Who's Ayla White? Who is the grand jury? The definitions. We start with the definitions, and you start, creating the whole story. So this story, how it's going to be performed, always, but the glossary of terms you're going to be using. In this case, who are going to be the people around this crime? For example, it's Russian, Belarus, Ukraine, and Suriname. So we have the definitions of what is a malware, what is a Trojan, what is a Christec login, etc., etc. And it continues. So we will have all the accusation here. This is all the prosecution basis. All of this is the prosecution evidence. All of this. So we have to see how we can do it in real life. Okay, so I'm gonna change it to Spanish so I can explain the whole thing. So let's go from the beginning. Ok, entonces en el simulador ahora de juicios que vamos a tener, primero tenemos que entender la diferencia entre las palabras y la traducción correcta y el contexto jurídico de cada palabra. En este caso, el simulador habla de un criminal trial. Entonces, este criminal trial es el juicio oral. Entonces, para hablar de juicio oral, aquí en Estados Unidos tenemos dos opciones: pre-trial y trial. Entonces, son acciones antes de juicio y acciones de juicio. En México tenemos audiencia inicial, audiencia intermedia, audiencia de juicio oral. Acá no. Acá nada más son dos: pre-trial y trial. Entonces, si es pre-trial, son todas las actividades antes de juicio, que fueron las que vimos en el video. Entonces, desde pre-trial es la investigación, cómo van los peritos, cómo aseguran el lugar, bla, bla. Pero ya que está en papel, es lo que vamos a ver ahorita. Entonces, ¿cómo pasa al papel? Bueno, primero empieza con un accusatory pleading, que son las acusaciones. Ese pleading es toda la carga acusatoria. Y después vamos a ver el citation, que es el paso número 2, cómo citar a las partes. La próxima clase vamos a ver, después de la citación, qué pasa, que es el indictment. ¿Sí? El indictment ya es la acusación per se. Entonces, después del indictment, sigue exactamente empezar a entender las cargas acusatorias, que le llamamos accusatory pleadings. ¿Y por qué se llama pleading? Porque lo vas a decir bajo protesta, decir, ¿verdad? Por eso es plead, you plead. How do you plead? Esa palabra es muy importante. ¿Cómo te declaras? How do you plead? Por eso decimos how do you plead. Si no, le diríamos how do you declare yourself. Pero no, decimos how do you plead. ¿Cómo se declara usted? Entonces, I plead guilty or not guilty. Significa me declaro culpable o no culpable. No hay inocencias. ¿Okay? O eres culpable o no culpable, pero no hay inocencias. Entonces, de ahí nace el que le digamos accusatory pleading, que es un formal written statement, es decir, es una declaración escrita formal presentada en la corte que carga o que acusa a un individuo con delitos u ofensas en específico. Entonces, esos delitos o ofensas ha sido toda la vida. El Ministerio Público, el District Attorney, tiene una figura acusatoria, no tiene de excepción, eso le toca al defensor. Aquí no hay asesores jurídicos. El único que le toca combatir en corte es el District Attorney, es decir, el Ministerio Público. Entonces, el Ministerio Público va a poder recibir la acusación ex parte, es decir, a petición de parte agraviada, pero el abogado que pueda hacer el indictment, literal, ese indictment de donde nace todo eso, lo va a hacer basado en una accusatory pleading, como en la acusación que vimos hace rato, quien hace la denuncia. Entonces, esa denuncia la puede hacer un abogado y ponerla a disposición del District Attorney. Pero el ponerla a su disposición es ponerle a él la carga probatoria. ¿Por qué? Porque yo nada más voy a ofrecer pruebas. El District Attorney le toca probar y ver cuáles pruebas son considerables formales o no formales. En los derechos de Marcy, vimos que uno de los derechos máximos es también de ofrecer pruebas y ser parte activa en el procedimiento acusatorio. Pero no significa que me voy a saltar al District Attorney. En la corte solamente está el District Attorney y el acusado. La víctima y su abogado van a estar siempre en el público. ¿Okay? En algunas ocasiones podrán estar si son activos procesales. Si no, van a estar ahí atrás, porque al que le toca hacer la acusación es al District Attorney. Entonces, en esa misma dimensión vemos que en el accusatory pleading vamos a ver los documentos delineados, los cargos en contra del acusado, que proveen la base de la teoría del caso o la teoría de la acusación, a lo cual lo vamos a llamar prosecution case. Ese prosecution case es la teoría del caso, pero ya abocada a una acusación formal. Y esta va a constar de 3 elementos. Siempre va a estar una violación legal, que decimos legal violation, violación a la ley o estatutos, que es statutes and laws, y los elementos del delito, que es elements of the crime. Estos elementos del delito lo vamos a dividir en actus rea y mens rea. En los estatutos es la conducta tipificada penalmente y la violación legal es cómo se conceptualiza subjetivamente esa acusación. Entonces, ¿en qué basamos los cargos? Si nos queremos defender o defender a una persona, siempre vamos a preguntar, what are the bases of the charges? Si no queremos sonar como abogados, simplemente decimos, what are the charges? ¿Cuáles son los cargos? Entonces, what are the bases of the charges? What are the charges? It allows the defendant, permite al acusado entender, y por eso va subrayado con diferente color, porque es primero que es entender que el acto, understand the actus rea. Lo primero que van a tener que saber, o la carga de acusación, tenemos que saber de qué se me acusa, ¿sí? Y si no es cognitivamente visible, hasta que lo haga el District Attorney. O sea, no nada más puede decir el District Attorney, se le acusa de este delito y a ver, que se lo explique su abogado. No, tendrá que probar, esa es parte de del ejercicio probatorio también. Hacer reconocimiento al acusado por qué le acuso de eso. Entonces, al por qué le acuso de eso, vamos a preparar enteramente su defensa. Entonces, al preparar, sí, dígame, Ulises.
Teacher, so the actus rea is related to the type of crime he committed, like we can say the murder or Grand Theft Auto, or
that's a game.
maybe.
But indeed, if there was a crime perpetrated or not, yes, the crime itself is the actus rea, what happened, the chain of events. The intention, what it was in his mind, is the mens rea.
Understood. Thanks.
Okay. And the thing here is that the accusation has to have a balance between the actus rea and the mens rea. If there is not a correct match between the mens rea and the actus rea, there is a doubt. So if there is a doubt, there is no crime. You understand? That's why we say beyond reasonable doubt. Por eso decimos más allá de toda duda razonable. Si no hay una carga probatoria entre la actividad intelectual, que es el mens rea, y el actus rea, que es el acto ya ejecutado, entonces me da a una duda. Si existe duda sobre la cadena de eventos perpetrados, entonces no hay delito. Muy interesante. Entonces, por eso esa relación entre el mens rea y actus rea y su consecuencia se llama causation. Entonces, esa causation nada más va a haber de dos tipos. Una directa y otra próxima, que le decimos direct causation y proximate causation. En el direct cause o direct causation, el acto es directamente dirigido, subordinado, lo que le llamamos la teoría del dominio del acto. Entonces, en ese direct acto o dominio, ese violation of harm, existe la relación del mens rea sobre el actus rea. Es decir, la persona quería, comprendía el alcance y consecuencia legal que dio el resultado material. ¿Sí? Entonces, por eso decimos direct cause. There is no direct cause. Proximate cause, o la causa próxima, es si hubo un daño sustancial que pudo poner una causa de justificación o de excepción a la culpa. En este caso, por ejemplo, en una persona que es abusada todo el tiempo, le pegan. Puede ser la esposa, puede ser el esposo ahora, ¿no? Todos los días está pégale, parece punching bag. Y un día de ellos, pues, se defiende y empuja y la tira de escaleras o lo tira de escaleras. Entonces, ¿hay causa de justificación? Sí, la eminente real defensa, pero no deja de haber delito. Entonces, por eso vamos a ver el actus rea, mens rea, como estos we have to be completely understood and proved. Tienen que ser completamente comprendidos y probados, ¿sí? Entonces, en ese probar, vamos a ver esa cadena de eventos, el chain of events. Cómo no se rompieron de manera seguida. Entonces, esos eventos que se nacen de manera seguida le vamos a llamar causation, ¿sí? Y esa cadena de eventos como tal se va a llamar cause in fact. ¿Cuál es la causa en facto? La causa de facto que fue que llevó a el delito. En el ejemplo que vimos, está el coche que se pasa todos los saltos que puede y uno de ellos es el que lo lleva ¿a qué? A privar de la vida a una persona que iba caminando a la misma hora. ¿Sí? Entonces, esa persona, la cual sufre directamente la acción, ¿hay un acto de dominio? Sí. ¿Pudo haber parado? Sí, pero no lo ejerció, una negligencia propia. Tal vez desde que se levantó no era su intención matar a esa persona, ni tenía como objetivo matar a la persona, pero lo terminó haciendo por una cadena de eventos que no paró. Esa cadena de eventos le llamamos direct cause, direct causation. Entonces, el direct causation is going to be the leading from the defendant's action or inaction. Puede ser la acción o inacción. Como en este caso, el no frenar a tiempo también es una inacción. Puede haber una situación de exculpa, sí, claro. Es decir, atenuantes a la conducta, sí. Pero tiene que ser experimentada, literal. Ver cómo fue la afectación directa a la víctima. Y recordemos, el que decide no es el juez, es un jurado. La próxima clase y la que le sigue vamos a estar viendo cómo el jurado implica una retrocognición, cognición activa, implícita, ¿en qué? En el despliegue y en el entendimiento de la conducta delictiva. Entonces, ¿cómo se ve una acusación en la vida real? Bueno, cuando ya hay un daño, ¿sí? Cuando existe el daño, empezamos a ver que el sujeto activo, el sujeto activo que es el carro, sobre el pasivo, ya tiene una consecuencia física. Aquí, nótese que son eventos que hubieran pasado o que pasaron y que uno llevó a otro. A eso le vamos a llamar past participle, pasado participio. Y en el pasado participio nuestra acusación tendrá que ser en presente infinitivo, pasado simple y después lo vamos a terminar en pasado participio. Entonces, en pasado participio siempre vamos a ver las acciones de acusación. Entonces, en el prosecution pleading, o sea, en la acusación, vamos a ver cómo pudo haber resultado en otra situación. Es decir, lo que yo voy a probar es la materia fáctica, pero también la de hipótesis de acción e inacción. O sea, ¿qué hubiera pasado si no se hubiera pasado todos los saltos del señor? ¿Qué hubiera pasado si hubiera ido a una velocidad constante? ¿Qué hubiera pasado si esa velocidad constante no es necesariamente la que puede privar de la vida? Todo eso se hace en oraciones en pasado participio, donde primera se pone el sujeto y sus elementos, como pueden ser pedestrian injuries, would, la palabra would, más not o sí, would, que es de posibilidad. Y el auxiliar have más el verbo en pasado participio. Vamos a estar viendo la gramática poco a poco, pero es muy importante en la redacción jurídica cómo tenemos que pasar de verbo activo, verbo pasado y verbo en pasado participio. ¿Okay? ¿Cómo se ve esa acusación? Bueno, vimos el caso de un cibercrimen. Así es como se ve un cibercrimen en la realidad. Y este cibercrimen, literal, fue bajo una acusación. Entonces, así se ve una acusación en la vida real. ¿Sí? Vemos quién lo está emitiendo, que es un US District Court. Entonces, se llama un juzgado de distrito. Desde que es un juzgado de distrito, es un juzgado federal. Lo está emitiendo el distrito de Florida, Miami. El case docket number, es muy importante que se aprenda la palabra docket, porque entonces vamos a ver docket. Docket significa el conjunto de todo lo que estás armando. Tu trabajo como abogado es armar un docket. Es decir, es la demanda, en este caso no hay demanda, es una denuncia y se llama indictment. Pero ya es la acusación, es cómo le estoy acusando a la persona. Entonces, indictment va a tener literal pruebas, cadena de custodia. Entonces, todo el gordito se llama docket. El case number, el número de expediente. Aquí está todo el número de expediente. Entonces, desde que vemos el case title, vemos que es un delito federal. ¿Cómo sé que es un delito federal? Porque dice los Estados Unidos contra White. Entonces, es el apellido de la persona y los Estados Unidos. Si fuera estatal, diría the State of California. Si fuera municipal, diría the County of Sonoma, por ejemplo. Entonces, depende mucho dónde lo estás haciendo y depende cuál es la visión de la acusación. Si es federal, es porque está en contra del Código Penal federal. Entonces, vamos a ver aquí a quién se le asignó. Se le asignó a la magistrada Alicia, que es Magistrate Judge, es superior. Entonces, son delitos graves. El acusado se llama Ayla White. Cuando nació, en 1965, es de origen ruso. La última vez que pasó a juicio es el 12 de febrero de 2021. ¿Cómo fueron notificadas las partes? Si hay algún tipo de deposición, si hay alguna acción procesal pendiente, cuál es el tipo de acusación. Le ponen none porque está por resolverse. Highest offense level tampoco, no lo están diciendo porque todavía no ha sido juzgada. Y en el complaint vamos a ver el tipo de delito. Y aquí tiene 1, 2, 3, 4, 5, 6 cargos. Entonces es conspiracy to commit computer fraud and aggravated identity theft. Entonces, cuando vemos la palabra conspiracy, no significa conspiración, que es lo que traducen mal las noticias. Conspiración es que hubo el direct causation, literal lo que acabamos de ver. Entonces, en la conspiración es todos los elementos en cadena que llevaron a poder llevar a cabo la conspiración o el fraude. Es decir, lo voy a probar, pero todavía no ha sido probado. Entonces hay una conspiración porque lo quiso, lo ideó y lo planeó. Y tengo probado los tres. Si no tengo probado los tres, entonces no lo puedo decir que es una conspiración. Por eso, aquí dice conspiracy to commit computer fraud and aggravated identity theft. Conspiracy to commit wire and bank fraud. Wire fraud, aquí sí le puedo decir wire fraud porque sí lo tengo probado. Bank fraud, aggravated identity theft, robo de identidad agravada y conspiración para lavar dinero. Entonces, cada vez que vamos a hablar de conspiración es porque no lo tengo bien probado. Hay algo, depende en juicio que lo voy a terminar de probar. Entonces, de tarea van a leer literal esta acusación. Vean cómo se arma el docket text. En el docket text vemos literal el control de cambios, vendría a ser el control de cambios para nosotros. Cómo viene del expediente, cómo se va armando el expediente y quién le está dando trámite. Entonces está la huella de cómo se arma el trámite y sobre todo dónde están los acuses. Aquí están los sellos, el timestamp, la hora del tiempo es muy importante. ¿Por qué? Porque vamos a ver si se hizo en tiempo el filing o no. ¿quién lo está promoviendo? Se promovió el 8 de febrero del 2021. Entonces, desde ahí empiezan a correr los términos. United States of America versus A.L. White. Aquí está el defendant y se ponen estos corchetes. Es una forma que todos tenemos que agarrar. En México hacemos las promociones como queremos y las promociones aquí es por orden. En esto vamos a ver cómo fue la acusación. Se hizo por arresto. Entonces, si se fue por arresto, ya hay un indictment. Entonces, ese indictment está señalando que se hizo por una acusación. Esa acusación la hizo un juez de distrito, perdón, un ministerio público. ¿Y cómo sabemos que el ministerio público lo fue? Bueno, aquí dice Angela Noble Clerk, U.S. District Court. Entonces, si queremos saber quién fue el ministerio público que lo hizo, aquí dice Angela E. Noble. Entonces lo podemos googlear luego, ver quién fue la ministerio público y si ha llevado otros tipos de casos iguales. Okay. ¿Alguna duda? Any question?
No questions, teacher.
I'll see you on Wednesday. Take care. Please review this video so you can check all the vocabulary. Practice. Remember that it's being in Spanish so you can understand better in English and Spanish, and you can stop the translating being used for you and also being used in your job because you work in a court, you work as a representative. So that's the most important thing, how we can understand the U.S. law, but also how we can practice the law itself. It was my pleasure. Thank you for being with me. I'll see you next class.
Thank you.
Bye-bye.